Happy Canada Day, and thank you for tuning in. Today is July 1st, 2023. I'm your host, Randolf Richardson. Today, I will be covering freedom in Canada and, from a legislative perspective, how our rights are protected by the Charter of Rights and Freedoms, which was added to our national constitution in 1982. The information that I will be covering is primarily sourced from the Canadian government official website that provides information, mostly educational, about the Canadian Charter of Rights and Freedoms. I will be interjecting from time to time with my own perspective as well. Thank you everybody for tuning in. I greatly appreciate everybody being here. So, first of all, I see Joanna, and look at the trees, and Fenton Mully and others in the live text chat. I appreciate you joining in our audience. Thank you very much for taking an interest in what's going on in Canada. I hope that everybody can hear me. What I'm going to do is begin with the series now. I'm going to start with with a quick overview of what the Canadian Charter of Rights and Freedoms is. It is an important part of our daily lives, for starters. The Charter of Rights and Freedoms, it protects fundamentally our basic rights and freedoms that are essential to keeping Canada a free and democratic society. It is a powerful force for progress, protection, and fairness, with the power to influence our society by interpreting laws and policies. The Charter ensures that the government, or anyone acting on the government's behalf, cannot take away or interfere with these rights or freedoms in any unreasonable way. Since 1982, the Charter has been an essential part of Canada's democracy, and it will continue to shape our lives, or shape our identity as a nation, as well as our lives. The Charter affirms that we are a multicultural society, and that it must be read and understood with this in mind. So therefore, it's accessible to everybody. The rights and freedoms guaranteed in the Charter govern how governments act, including the right to equality, freedom of expression, and the right not to be deprived of life, liberty, or security of the person, in particular, except in accordance with the principles of fundamental justice. We will be getting into that as well. It also protects the rights of First Nations, Inuit, and Métis in Canada. The roots of the Charter lie in the desire for Canada to gain full control over its constitution. Because Canada's original constitution was an act of the British Parliament in 1867, only Britain originally had the power to change our constitution. In 1980, Canada and its provinces and territories began a collaborative process to bring home the Constitution and incorporate a Charter of Rights and Freedoms into it. A committee of Canadian parliamentarians, representing all parties, considered more than 1,200 written submissions at the time and over 300 testimonies to develop the final charter. So there was a lot of involvement from our society in the formation of the Charter. It wasn't just politicians acting alone on this. Well, they would be acting in our best interests, is the intention anyway. Receiving approval from Britain for the last time, Queen Elizabeth II signed the Canada Act on April the 17th, 1982, while she was in Ottawa. That's in the province of Ontario. This action gave Canada control over its constitution and guaranteed the rights and freedoms in the Charter as supreme law of the nation. The Prime Minister Pierre Trudeau signed the proclamation in a sitting in person with Queen Elizabeth II, and the Minister of Justice at the time, Chrétien, also signed the proclamation of the Constitution Act. This was a major change for us in Canada because now we were sovereign. We were in control of our own constitution as a society, as a country. The rights and freedoms protected by the Charter are divided into 7 categories. These categories address Canadians' fundamental freedoms: democratic rights, mobility rights, equality rights, official language rights, and minority language educational rights. How the Charter has shaped Canada is that it allows individuals to challenge government actions that are believed to violate rights or freedoms, and to challenge our government on other matters as well, due to freedom of expression, freedom of opinion, and other aspects of Section 2 of our Charter. The most complex and controversial Charter-based challenges typically end up before the Supreme Court of Canada. In the past, these challenges have set legal precedents and also inspired significant changes to federal, provincial, and territorial legislation, laws basically. The government can put some limits on individual rights, but it has to be justified. The Charter recognizes that even in a democracy, rights and freedoms are not absolute. That is the nature of being in a society. You are a member of society, you have rights, so does everybody else. So while you're free to exercise your rights, so are other people. And everybody has these rights to participate and not have their own rights overruled or infringed upon. So, Section 1 of the Charter allows the government to put limits on rights and freedoms if that limit meets 3 criteria. It's set out in law, it pursues an important goal which can be justified in a free and democratic society, and it pursues that goal in a reasonable and proportionate manner. Section 33 of the Charter, also referred to as the Notwithstanding Clause by many people, allows Canada's Parliament, provincial and territorial legislatures to pass laws that may violate certain rights, certain charter rights. A legislature may do this if they clearly state to the public beforehand that they are passing a law that violates the Charter and which rights in particular the law infringes. They have to be accountable, they have to be transparent, they have to be specific. All levels of government must review and reenact this declaration to Canadians every 5 years, or the limits are automatically lifted. The federal parliament has never used the Notwithstanding Clause. If the government limits your rights without good reason, if an individual thought the government had put limits on individual rights without good reason, that is, a court challenge may be brought forward. If the court agrees with the individual who's brought the claim, a court may order a remedy. The Charter sets out 3 types of remedies, which are actions intending to compensate for the rights violation in question. First, the claimant can ask the court for a remedy that is appropriate and just in the circumstances. Second, a remedy may be available when authorities, such as a police officer, has carried out investigations that have violated a person's charter rights, which could happen, for example, when police improperly search for evidence on private property and violate a person's right to their privacy. So a third is if the court finds that a law or a section of the law violates a person's charter rights. The court can issue a declaration saying the law is not valid. And that's how some laws get overturned. And we will sometimes see when we're looking through the criminal code, for example, certain laws that have been removed, and it'll indicate when they've been removed. So the number is still there, but the law itself is gone. The Charter guarantees many basic human rights and fundamental freedoms. We have other human rights protections that come from federal, provincial, and territorial statutes, common law, and international law. In 1960, the Parliament of Canada passed the Canadian Bill of Rights, which was the first federal human rights law in the country, and it guaranteed basic rights and freedoms in federal law for the first time. It was not enshrined in our Constitution, however. So it was not the supreme part of the law, but it was federal law, which means it applied to the whole country. The Canadian Human Rights Act passed in 1977, prohibits discrimination in the context of federal employment and provisions of goods and services and facilities or accommodations generally available to the public, so publicly accessible areas. It prevents discriminatory practices based on a number of grounds, including race, national or ethnic origin, sex, and disability. Sexual orientation has since been added to that as well, I believe. The Act applies to the Government of Canada, First Nations governments, and federally regulated private businesses, including in banking, airline, telecommunications, and broadcasting, and interprovincial transportation sectors. All provinces and territories have similar human rights laws that apply within the province or territory, so they similarly apply to provincial or provincially regulated works and undertakings. So that's just a quick overview of this, of our charter. It is, I'm going to get into what the sections of the charter are in a moment. There are general principles for the interpretation of our charter and our constitution that are essential for our system of justice to be functioning well. And the Canadian Charter of Rights and Freedoms forms a part of the Canadian Constitution that should be interpreted in this kind of fashion. Specific aspects of charter interpretations include what's called the purposive approach. So it's purposeful, but they call it purposive. A purposive analysis is the cornerstone of charter interpretation. It requires that rights be given a generous and liberal interpretation aimed at fulfilling the purpose of the right in question and of the charter as a whole. The central concept of the purposive approach is that the meaning of the right must be understood in light of the interests it was meant to protect. This requires consideration of the relevant linguistic, philosophic, and historical contexts. Regard must be had for the language used, other charter rights which the right is associated, and the need for charter rights to be capable of development over time. Charter rights should be read broadly, putting the burden of justifying limitations on the state, on the government that is. It is important not to overshoot the purpose of the right in question. So, internal exceptions to charter rights should be subject to the same interpretive principles. Courts should not undershoot the purpose of a charter exception by giving it an unduly narrow interpretation as well. So it has to be generally well centered around what that right is. Within the purposive approach, the analysis must begin by considering the text of the provision. Giving primacy to the text as the first factor to consider within the purposive approach prevents an interpretation that overshoots or undershoots the purpose of the right. The principle that a provision bearing more than one plausible meaning must be read in a manner that favors the accused is the principle of penal statutory interpretations, but not one of charter interpretation. Charter rights and freedoms do not automatically receive the most generous interpretation, the individual does, that their language can bear. While charter interpretation is to be liberal, this is subordinate to the purposive approach, meaning that charter rights must be interpreted liberally within the limits that their purposes allow. I know that sounds a bit complicated. There's a lot there. There's another aspect of contextual analysis. Another interpretive doctrine regularly invoked in conjunction with the purposive approach requires that the charter question be situated within the actual social, political, and legal context in which it arises. For example, regulatory versus criminal matters, citizens versus non-citizens, like people who are visiting from another country would be an example of a non-citizen. Or it would be examples of non-citizens. Contextual analysis will often involve a consideration of the principles and the policies underlying the law or area of law in question. When legal rights are at stake, the contextual approach suggests that the charter will be interpreted more flexibly, where the relevant state action does not threaten the individual with the risk of imprisonment. So the goal here is to try to favor, as much as possible, keeping people from ending up in prison if it's a serious matter even with a serious matter that's being considered. This is better for society because quite often people do make mistakes. Most people are not experts in law and legal matters, and so giving them some extra flexibility here and kind of having the goal in mind to keep them out of prison is actually better for them as well as society as a whole. Now, if somebody has done something really terrible, such as committing a violent crime, and they've done it with full intent, or they planned it or whatever, then obviously there needs to be something done. And that's where there needs to be some rehabilitation combined with a prison sentence or something like that. There needs to be some kind of approach to encourage a person not to do it again in the future, which is kind of in line with this. Sort of. The contextual approach is also relevant to the determination of the appropriate balance to be struck between individual rights and societal interests. Whether this balancing occurs within the substantive right itself. So, the contextual approach may also be applied in determining the appropriate remedy to be granted. So, consequently, charter analysis is highly fact-driven. So our laws value the facts. This is very important. Like, you've got rules of evidence and whatnot in the court cases. If you have scientific facts to back up why something happened, that certainly is helpful too, depending on the nature of whatever court cases in progress, I suppose. Charter decisions should not and must not be made in a factual vacuum. To attempt to do so would trivialize the Charter and inevitably result in ill-considered opinions. The presentation of facts is not, as stated by the respondent, a mere technicality. Rather, it is essential to a proper consideration of Charter issues. Textual analysis refers to an interpretive approach which relies strictly on a provision's wording in order to interpret the rights conferred. The Supreme Court has, on occasion, attached great importance to the text of Charter provisions, and the Charter is a very well-written document. There's a lot of interesting considerations that have been made with regard, particularly Section 1 will be of great interest in this consideration. A textual analysis has been applied on occasion to Charter provisions dealing with language rights on the basis that such rights are, unlike, for example, legal rights, founded on political compromise, and may, for that reason, be narrowly interpreted. However, in other cases, the Supreme Court has indicated that language rights may still be interpreted in a purposive, albeit prudent, manner. Interpreting a charter right. In interpreting a charter right, all parts of the text must be given meaning. As well, other charter provisions may assist in determining the content of the right in question. There are many provisions in our charter which are largely interpretive in nature. So that, of course, necessitates having a court process, having people who are experts, scholars, lawyers, and other people who work with this to try to help resolve situations that bring these interpretive aspects to the front lines. We are a bilingual country. We have French and English as our official languages nationally. And both these languages are always made available through federal government services, and schools also teach both languages as well as other languages. We're not limited to these two languages, but we have these. And the Charter is written both in English and French, and as between the English and French versions, while both are equally authoritative, the less ambiguous version should govern. So the one that is more clear is in its wording, is the one that we want to prefer to use as being the authority in what the rules are that governs our society. We want that consistency. It'll be we'll have better results this way, better court decisions, because we have more consistency in the decisions and more fairness as a result, or more equality coming out of the decisions. External aids to charter interpretation may be informed by reference to a number of external sources. The various charter pedia entries contain a segment outlining the major relevant Canadian, comparative, and international law sources for particular substantive provision. I'm going to skip a bunch of this because there is, I think the rest of this is probably, okay, there's one aspect here I wanted to cover. Balancing competing charter rights. It can be the case where you may have competition between two different rights, not in the sense of a sports game or something, but just in the sense that there is some overlap and a little bit of a conflict because they seem to contradict each other a little bit. This can happen in any legal system because there can be complications. So there's a balancing approach in this, and that is that no right, including freedom of religion, is absolute. There have been a few cases that take this into consideration. This is so because we live in a society of individuals in which we must always take the rights of others into account, which is something I touched on at the beginning, just after as part of my introduction. In the words of John Stuart Mill, the only freedom which deserves the name is that of pursuing our own good in our own way, so long as we do not attempt to deprive others of theirs or impede their efforts to obtain it. And that was on liberty and considerations on representative government in 1946 at page 11, in case anybody would like to read more of that. John Stuart Mill is a well-known philosopher. In the real world, oftentimes the fundamental rights of individuals will conflict or compete with one another. There is no hierarchy of rights within the Charter. A hierarchical approach to rights, which places some over others, must be avoided, both when interpreting the Charter and when developing the common law. When the protected rights of two individuals come into conflict, Charter principles require a balance to be achieved that fully respects the importance of both sets of rights. And to be clear, this is not a compromise. This is finding a balance. This is finding a scenario, an outcome that will be at least satisfactory as much as possible and more beneficial to all the parties involved. The potential for collision of charter rights does not necessarily imply unconstitutionality. The collision between rights must be approached on the contextual facts of actual conflicts. The first question is whether the rights alleged to conflict can be reconciled. Where the rights cannot be reconciled, a true conflict of rights is made out. In such cases, the court will find a limit on the right that is the basis of the challenge and go on to balance the interests at stake under Section 1 of the Charter. Should impermissible conflicts occur, the provision at issue will fail the justification test under Section 1, which we'll get into. Section 1 is very interesting, and the conflict will cease to exist. In both steps, the court conducts its analysis on the basis that the Charter does not create a hierarchy of rights, and Charter rights should be read broadly. So, one part of the Constitution cannot be used to invalidate another part of the Constitution, or the applicant. And this is a very important concept. And this thinking is part of the reason why the notwithstanding clause, Section 33, is controversial. But this is a very important thing, where the application of the Charter would negate or invalidate the very existence of another constitutional power or right. The Charter should not be applied. It was never intended that the Charter could be used to invalidate other provisions of the Constitution, particularly a provision such as Section 93, which represented a fundamental part of the Confederation Compromise. The test, and that's part of the reason why Quebec can do language laws, but nobody else can. I'm hoping that will change in the future, and they will stop doing that. Because I do think that is a violation of Section 2 of our Charter and rights and freedoms. The test is whether to accede to the Charter argument would amount to negating or removing a constitutional power. If so, the Charter does not apply. That is the general thinking behind this. However, the Charter may be applied to constrain the exercise of a particular constitutional power as long as it does not negate or invalidate the power itself. So there's some subtlety and nuance here. The important question is whether we are here treating the fruit of the legislative tree or the tree itself. And that came from New Brunswick Broadcasting Co. and Nova Scotia, Speaker of the House Assembly in 1993. 1 SCR 319. In certain factual situations, the question of a waiver of rights or consent that would otherwise be a violation of rights may arise. It is unclear whether one can waive certain charter rights as a freedom of religion or equality. The court has suggested, in the context of the right to an interpreter in a criminal trial, that there may be some rights in the general public interest that cannot be waived. It is in which the court considered that an individual right, such as the right to the benefit of a jury trial, guaranteed by Section 11F of our Constitution, should be capable of waiver by the individual whom the right is designed to protect, even if such rights may have a public interest aspect. See also Carter Supra at paragraph 63. Waiver has been disapproved of in respect of human rights legislation. Contracting parties, such as labor relations contracts, are not competent to contract themselves out of anti-discrimination provisions of human rights legislation, so it's not allowed. Contracts having such effect are void, as contrary to public policy. This is very important because otherwise somebody could be tricked into signing their rights away. Waiver has been recognized as possible in respect of certain charter rights, such as for waiver of any charter right to be effective, it must be voluntary and fully informed, a clear understanding of the true consequences and effects of the waiver of rights. One rights holder cannot waive another holder's rights on their behalf. We see vicarious redemption coming from Christianity, for example. That would not be permitted under the waiver of rights restrictions. The waiver of rights is also pretty important for people who are accused of a crime. It did touch on this a little bit. So I'm going to move on to the next part here, which is the Charter itself. Section 1, reasonable limits. So the provision is Provision 1, more commonly referred to as Section 1. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. The purpose is, well, when enacted in 1982, Section 1 of the Charter represented an innovation in human rights law. Oh, I see more people have joined our live text chat. I'll just say hello, Mr. Forestbeard, meow meow, thank you. Brucifer Higgingsworth is asking, is Canada Day the day they come out of hiding after America defeated the British? Is that a Canadian lag or American? Just kidding. Love me some Godfather of Atheism. Well, thank you very much, Brucifer. I do appreciate that very much. I do not know the answer to your question. Big Bad Mama, hello. Happy Canada Day to you too. Thank you very much for that. So, Section 1, basically, it talks about... Section 1 of our Charter, when enacted in 1982, represented an innovation in human rights law, as it set out a general framework for justifying limits on rights and freedoms guaranteed in the Charter. There is no similar provision in the Canadian Bill of Rights. Hello, Germania. I see you've just joined our audience as well. What? Suddenly a rare Randolf Richardson solo stream appears. Yes, I try to run a Canada Day stream every July 1st because it's Canada Day here. And we're 3 days before the Americans have their days. So it's good we're not on the same day, I think, because it gives us a chance to... Yeah, thank you for your support, Germania. I do appreciate that. So with respect to international instruments binding on Canada, somewhat similar provisions may be found in the International Covenant on Economic, Social, and Cultural Rights. And there are also other comparative law instruments that are not legally binding on Canada, but include similar provisions. Like if we look at South African Constitution's Bill of Rights, it includes very similar general limitation clause in Section 36. ours is in Section 1. We start right out of the gate running with this, so everybody understands. It sets a tone in a way. The European Convention on Human Rights contains limitation clauses which are specific to rights and freedoms guaranteed under the Convention. Articles 8, Section 2, right to privacy. 9.2, freedom of thought, conscience, and religion, which we have in Section 2. 10.2, right to freedom of expression. For us, that's Section 2. And 11.2, right to freedom of peaceful assembly and right to freedom of association, also Section 2 for us. That convention, however, does not contain a standalone limitation provision. The United States Bill of Rights does not contain a similar provision. The purpose of Section 1 is that it effects a balance between the rights of the individual and the interests of society by permitting limits to be placed on guaranteed rights and freedoms. Most modern constitutions recognize that rights are not absolute and can be limited if this is necessary to achieve an important objective and if the limit is appropriately tailored or proportionate. The values and principles which guide the court in applying Section 1 include the inherent dignity of the human person, commitment to social justice and equality, accommodation of a wide variety of beliefs, respect for cultural and group identity, which is essential for being a multicultural society, and faith in social and political institutions which enhance the participation of individuals and groups in society. And this is one of the things that the Charter serves so very well, and that government did very well under Pierre Trudeau, Prime Minister. He brought this in. He made this happen. It was an effort by many people to make this happen, but he was our Prime Minister at the time. And for those who are wondering, yes, Pierre Trudeau is Justin Trudeau's father. So, now Section 1 is engaged only after a finding that has been made that a right or freedom has been limited. The onus of proof under Section 1 is on the person seeking to justify a limitation with it, which is generally the government. So the government is usually the one who would try to justify imposing a limitation. The standard of proof is the civil standard, or balance of probabilities. And the Oakes test is considered in all of this. Oakes test, by the way, is spelled O-A-K-E-S, if you wanted to look it up. Demonstrably justified connotes a strong evidentiary foundation. Cogent and persuasive evidence is generally required. Where scientific or social science evidence is available, it will be required. However, where such evidence is inconclusive or does not exist and could not be developed, reason and logic may suffice. Again, this necessitates having judges so that they can try to guide things in the right way. The prescribed in law portion is in order to be capable of justification under Section 1, the limit on the right or freedom must be prescribed by law. The limit may be either express or implied in a statute or regulation, or a common law limit, assuming there is sufficient government action for the Charter to apply. Discretionary administrative decision-making limiting a right or freedom was previously regarded as a limit prescribed by law under Section 1 and subject to the traditional Oakes test. So, there are more things on this. The Oakes test: a limit on a charter right must be reasonable and must be demonstrably justified. So again, the emphasis is on freedom and not on limiting people. The applicable test was originally set out in Oakes, O-A-K-E-S, and is now well established. For example, see Egan and Canada. They put V period as Latin for and. A lot of people think it means versus. It actually means and. And lawyers who've been in the field for a long time tend to know this. That was a case in 1995. Another case in 1998 was Vrend and Alberta. Canada, let's see, and there was also the Attorney General of Canada and Hislop in 2007. So there's a number of case law cases in case law that support this. So the Oakes test we have to ask these questions. These questions have to be satisfied. Is the legislative goal pressing and substantial? For example, is the objective sufficiently important to justify limiting a charter right? And 2, is there proportionality between the objective and the means used to achieve it? The second branch of the test has 3 elements. The first one is rational connection. The limit must be rationally connected to the objective. There must be a causal link between the impunged measure and the pressing and substantial objective. The second branch, the second element of the second branch is B, the minimal impairment. The limit must impair the right or freedom no more than is reasonably necessary to accomplish the objective. The government will be required to show that there are no less rights-impairing means of achieving the objective in a real and substantial manner. So, reasonably necessary is, again, a subjective point, and that's why this is such an important thing. So the third element of the second branch of the Oakes test is C, final balancing. There must be proportionality between the deleterious and salutary effects of the law. Application of the Oakes tests should not be approached in a mechanistic fashion. Rather, it should be applied flexibly, having regard to the factual and social context of each case. And flexibly, I guess, would be including keeping in mind how to keep people out of prison rather than putting people into prisons. So again, this is what we're trying to do. We're trying to make society safer and better for everyone with our 1982 charter here. Now, somebody just joined our audience again. Hello to Robert X. Thank you for joining us. It's always great to see you here. Pressing and substantial objective. I'm going to skip the rest of these. Proportionality. The means used to obtain the objective of a provision must be proportional to the importance of that objective. And there's a 3-step analysis for that. I think this is getting pretty detailed and not really going to help us with understanding this part. So again, I'm just going to go back up to the beginning of this section 1 of our charter. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. And there are a number of legal instruments that help for courts to make decisions that are fair and reasonable and not overshoot or undershoot our charter rights. Oh, Robert X, thank you for your support. I do appreciate that. Now, section 2 is my favorite section of this. I have a number of favorite sections. Number 2 is right at the top. So section 2 has 4 elements in it, lettered A through D. So section 2A is freedom of religion. Section 2B is freedom of expression. Section 2C is freedom of peaceful assembly, and section 2D is freedom of association. So 2B is probably my favorite part of all of this, but we'll do them in order. So section 2A, freedom of religion. Everyone has the following fundamental freedoms: freedom of conscience and religion. So conscience would be your belief in a deity, or your feeling that a deity is real. You have the right to do this in Canada. Now, freedom of religion is one that is sometimes misunderstood, as because some people think it means that you can do the horrible things that are in the religion, but then that would infringe on other people's rights. So there's a limit there, and we'll get into that in just a moment. Now, there are similar provisions that are found in Canadian and international laws. Well, Canadian laws and international instruments that are legally binding on Canada. Section 1 of the Canadian Bill of Rights, which is the predecessor to a great degree to the Canadian Charter of Rights and Freedoms. The Canadian Human Rights Act is probably the best place to look. This one prohibits discrimination on the ground of religion, as does Section 15 of our Charter. And that's another favorite section of mine because it prohibits discrimination. The purpose of Section 2A is to prevent interference with profoundly held personal beliefs that govern one's perception of oneself, humankind, nature, and in some cases, a higher or different order of being. So, freedom of religion has been defined as the right to entertain such religious beliefs as a person chooses, the right to declare religious beliefs openly and without fear of hindrance or reprisal, and the right to manifest religious belief by worship and practice or by teaching and dissemination. That's very important. You can hear how that's kind of more specific now. We have clarification here. The term religion has not been specifically defined, although the Supreme Court has stated that beliefs or practices rooted in secularism are not protected by the guarantee of freedom of religion, and further, that religion typically involves a particular and comprehensive system of faith and worship, a belief in a divine, superhuman, or controlling power, and or a personal conviction or belief that fosters a connection with the divine or with the subject or object of that spiritual faith. Note, however, that the court has also stated that the rights of atheists, agnostics, skeptics, etc., and the unconcerned are equally protected by Section 2A. So, even though it is freedom of religion, and it's fantastic that people have these rights, and I'm in support of this. I'm an atheist myself, I'm agnostic, and I strive to be a proper skeptic. These rights are the spirit, pun not intended, the spirit of this section of the Charter of freedom of religion is also meaning the freedom to not be religious. You could not call it a freedom if you said freedom of religion means you have to be religious. There are some countries where certain politicians have blown off silly ideas saying freedom of religion means you have to choose a religion. In Indonesia, they have a law there that when you turn by the age of majority, you have to choose a religion or suffer time in jail if you refuse. So, and they have 5 religions to choose from. So there's different countries doing different things. In Canada, we have no such restrictions. You can be a member of any religion you like. The Jedi religion is just as valid as Christianity, just as valid as Buddhism, just as valid as Jainism. The big Kahuna religion that was in Hawaii before Christianity moved in and replaced it. It apparently wasn't a friendly replacement, as history has it. And any other religion, there are more than 75 religions I could list, and I've just listed about 4 or 5 of them here as examples. Atheism not being a religion, and same with agnosticism, is also equally important. And we do have in later provisions in later sections of our charter equality rights that are protected. So this is actually consistent with the equality clause in our Constitution. So this is very good in our charter. The Supreme Court has interpreted Section 2A broadly, with a stated preference for leaving competing state interests, including competing rights, to be reconciled under Section 1, or through the proportionality analysis in the case of judicial review of administrative decisions, rather than formulating internal limits to the scope of freedom of religion. Section 1 is considered a more flexible tool for balancing competing rights. It's very often equality rights of other individuals. The Supreme Court has stated on many occasions that freedom of religion can be limited where it interferes with the fundamental rights of others. For example, child sacrifices. If your religion requires child sacrifices, then you do not have the right to practice that here in Canada, because that would violate the rights of any children that are to be sacrificed. So, and they have the right to security of the person. So, when individual rights come into conflict, the conflict ought to be resolved through the proper delineation of the rights and values involved. hello to Regios. I hope I'm saying your name correctly. Are there some technical difficulties going on right now? Not that I'm aware of. Are you noticing some technical issues? In Law Society of British Columbia and Trinity Western University in 2018, and its companion case, Trinity Western University and Law Society of Upper Canada. I know this case because I was encouraging people behind the scenes to push this through and make this happen. The Supreme Court chose to reconcile the competing religious freedom of evangelical community members of TWU, Trinity Western University, with the equality rights of LGBTQ persons through the proportionality analysis at the second stage of the Dorr-Loyola framework for the judicial review of administrative decisions that engage charter rights. The majority found that the impact on the religious freedom of TWU community members was of minor significance, and that the Law Society's decisions represented a proportionate balance with the significant statutory objectives of ensuring LGBTQ equality and public confidence in the legal profession. Now, what happened is the TWU had a covenant and they also are a school that has law professors teaching law in British Columbia, Canada. And their covenant was discriminatory, had elements in it that was discriminatory to the LGBTQ demographic. And so that had to be corrected or removed as a requirement for law students, because people practicing law have the right. So there's a discrimination aspect. One of the aspects I was also promoting is that we all have equal access to and equal benefit of the law here in Canada. That's also later in apparently my video is frozen. I am sorry about that. I wasn't expecting a frozen video. I don't think anybody ever expects these things. Let's just see what's happening on the YouTube stream. What is going on? Why is my video frozen? Can you hear my voice? I have to find out if people can hear me. I hope people are hearing me. Thank you, Regios, for pointing this out. Let me just turn up the volume here and see if I can hear myself. That's well, I guess people can hear my voice. Let me see if I can fix the picture here. We shouldn't be having this problem with the video. I'm surprised. Maybe the video is working now? I wonder. Okay, so I'm not sure why the video is freezing up. We had some nice video there. I guess I'm going to have to turn off that. I'm going to have to turn off the video. I do not know what happened there. I am concerned about that, obviously. We don't want that to be... Okay, I wonder if this is going to fix it somehow. I apologize for this delay. Yes, you can hear me. Seems to be some buffering now as well. Okay. This is strange, because I've done numerous streams like these before without a problem. I do not know why I'm having issues here. Maybe if I turn off this video. Maybe people can see me now. Simus Funk, welcome to our audience. Thank you for joining us. I appreciate you being here. I'm just going to try to keep the video change to the Cobra Chicken, aka Canadian Goose Cobra Chicken. That is funny. Let me see here. hope that we can have some video working in a moment here. Wow, these things are not without their challenges. So I guess I hope that the video is coming up now. I'm going to have to mark this as a short intermission later. Again, I do not know what's happened here. We had... Okay, if I turn off the video source, maybe that will help. I wonder. Let's see if we start getting some video now. Again, I apologize for this. I had all these nice videos going. So, I'll just continue talking because what's important is what I'm talking about, more so than what we had going. So, so the Supreme Court, Law Society. So that was part of that case. There was an issue that got resolved actually with that, because the courts decided, and they took this all the way up to the Supreme Court, and then the Supreme Court ended up favoring us. And hello Sandy, thank you for joining us. Okay, I see Canada hasn't fixed the internet lag issue yet. Happy freedom. I wished I wasn't having these issues today. I apologize for that. I had all these nice videos to show while I was talking, showing different places in Canada. At any rate, so the scope of Section 2 is not, however, without limits. There was a majority of the Supreme Court held that an Indigenous spiritual freedom claim to the protection of a sacred mountain valley site from a proposed ski resort development did not fall within the scope of Section 2A, which does not protect the objective beliefs or the spiritual focal point of worship and the subjective meaning derived from them. So freedom of religion comprises both an individual aspect and a collective aspect. The Supreme Court has noted that religion is about both religious beliefs and religious relationships. Recognizing the linkages between religious belief and its manifestation through communal institutions and traditions, the court has found that measures that undermine the character of lawful religious institutions and disrupt the vitality of religious communities represent a profound interference with religious freedom. So, that's as far as the Law Society, British Columbia, and Trinity Western University, a majority of the court found that the refusal of the regulatory bodies to accredit a new law school governed by a mandatory covenant, which precluded sexual relations outside marriage between a man and a woman, engaged Section 2A of the Charter by limiting the ability of members of the TWU community to enhance their spiritual development through studying law in an environment defined by their religious beliefs. In collective-type claims, freedom of religion may encompass or intersect with other rights, such as freedom of expression, freedom of association, and equality. The question of whether corporations or other entities can claim the right to freedom of religion remains open. While a corporation's ability to claim Section 2A rights remain unclear, a corporation can challenge the constitutionality of a law under which it is being prosecuted on the basis that the law infringes an individual's freedom of religion. More about standing to bring charter claims. Yeah, there's analytical framework and whatnot, and this starts to get pretty detailed. Freedom of conscience. Let's see. While the Supreme Court has not given much consideration to freedom of conscience, it has noted that this aspect of Section 2A includes the right not to have a religious basis for one's conduct. In the concurring judgment, freedom of conscience. Okay, freedom of conscience and religion should be broadly construed to extend to conscientiously held beliefs, whether grounded in religion or in a secular morality, and the terms conscience and religion should not be treated as tautologous if capable of independent, although related meaning. The Federal Court of Appeal has held that freedom of conscience is aimed more broadly at protecting views based on strongly held moral ideas of right and wrong, not necessarily founded on any organized religious principles, and distinguishable from political or other beliefs, which are protected of Section 2B, freedom of expression. So what I'm going to do is just take a moment here to try to find out what's going on with my video, and then we'll go on to Section 2B. Again, I appreciate your understanding with this. I'm sorry that this happened. Let me see. This is, again, I thank everybody for your support and patience and understanding while I go through this. This is we even have the live chat up on the screen, trying to make sure everybody can see it okay and access what they need to. What has happened here with this? Why is this doing this? Just taking a look at the settings here. Maybe there's something in the settings that I need to do. Bitrate 2500, audio, video. Nothing about bitrate there. Advanced. Everything seems okay here. What is... I'm very sorry, folks. I do not understand why this has happened, and I'm not seeing anything that will give me a solution for it. This is... I've not had this problem before. What I'll do is I'll finish up Section 2, and then I think I'll stop it there. I'm just going to quickly go through them because I don't want to leave the pace at which I'm moving here on this. Perhaps you can still hear me. I'll just have the freedom picture up for now. That's... I guess this is going to be an audio-only stream at this point. So, Section 2B of our Charter, everyone has the following fundamental freedom: freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. So there's similar provisions in other parts of law, in Canadian law and elsewhere, including the Bill of Rights. The purpose to protect the protection of freedom of expression is premised upon fundamental principles and values that promote the search for and attainment of truth, participation in political decision-making, and the opportunity for individual self-fulfillment through expression. So Robert X is saying Canada should take over the USA and put their religious laws in place over there. You know, there are people who have said this before, and it is something that does come up from time to time, I've noticed. So I don't know. I'm wondering if I've lost my audio here, my video here, because I'm not seeing it show up on my own web browser in the other window here. Okay, that's so strange. I do have a recording going at this time. The Supreme Court of Canada has maintained that the connection between freedom of expression and the political process is perhaps the linchpin of Section 2B protection. Free expression is valued above all as being instrumental to democratic governance. Yeah, if you can't get feedback from your constituents, how can you govern them effectively, you know? The two other rationales for, effectively and fairly, the two other rationales for protecting freedom of expression, encouraging the search for truth through the open exchange of ideas, and fostering individual self-actualization, thus directly engaging individual human dignity, are also key values that animate Section 2B analysis. Give me just one moment. I'll be right back. Okay, so the analysis is that the Canadian courts have interpreted Section 2B very broadly, often finding a prima facie breach easily. The Supreme Court has adopted the following three-part test for analyzing Section 2B. 1. Does the activity in question have expressive content, thereby bringing it within Section 2B protection? 2. Does the method or location of this expression remove that protection? And 3. If the expression is protected by Section 2B, does the government action in question infringe that protection, either in purpose or effect? Hello, What the Beck. Thank you for joining us. I haven't seen you around for a while. It's great that you're tuning in. I've run into some audio problems, but my video is still I run into video problems, but my audio is still working. So we're just talking about Canadian Charter rights here. So does the activity in question have expressive content, thereby bringing it within to Section 2B protection? Expression protected by Section 2B has been defined as any activity or communication that conveys or attempts to convey meaning. The courts have applied the principle of content the principle of content neutrality in defining the scope of Section 2B, such that the content of expression, no matter how offensive, unpopular, or disturbing, cannot deprive it of Section 2B protection. Being content neutral, the Charter also protects the expression of both truths and falsehoods. Freedom of expression includes more than the right to express beliefs and opinions. It protects both speakers and listeners. Expression may include all phases of the communication, from maker or originator through supplier, distributor, retailer, or exhibitor to receive, whether listener or viewer. I'm going to just try switching. Oh, we're not seeing any video there at all. I wish. So there's a delay of about 15 minutes from Randolph being able to read chat and video output on my end. Wow. 15-minute delay. Okay. I don't know why we're having this delay. Alright, folks. I'm going to try... darn it. I'm going to have to continue this stream another time. You can hear me just fine, so that's good. So freedom of expression includes more than the right to express beliefs and opinions. It protects both speakers and listeners. Expression may include all phases of the communication, from maker to originator, through supplier, distributor, retailer, renter, or exhibitor to receiver, whether listener or viewer. So basically people can communicate with anybody in all directions if there's a whole bunch of people. Protected expression has been found to include more than just speech. It includes music, art, dance, postering, putting up posters, physical movements, or posturing, sorry, physical movements, marching with banners, and so on. Commercial advertising is also included under protected expression. Another example is posters on utility poles. Another one is peace camps. Another one is signs and billboards. Another one is picketing. So people going on strike, for example. Another one is handing out leaflets. Another protected expression is expressing oneself in the language of choice. Another one is hate speech, is unfortunately protected. Now we have some restrictions on there that are consistent with Section 1, And what's happening is people are objecting to it because they're ignoring Section 1. But Section 1 definitely justifies it. Pornography is protected expression in Canada. Child pornography, however, we do have restrictions, again, that fall back to Section 1. And so it is illegal to distribute child pornography in Canada. It is illegal to produce it. It's also illegal to, in addition to that, it's also illegal to advertise that you have it, regardless of whether or not you have it. Hello to Kevin Lentini Music. Thank you for joining us. I really appreciate you being here. Happy Canada Day. We're having some video problems, but the audio seems to be working. Communication for the purpose of prostitution is protected as free expression. Noise being emitted by a loudspeaker from inside a club onto the street is another example. Another example of free expression protection is importation of literature or pictorial material. Another one is defamatory libel. Now, there can be consequences with defamatory libel because you can also be sued for that, and there are libel lawsuits that do occur sometimes. Voting is considered a form of free expression. Running as a candidate for an election, spending in election and referendum campaigns, broadcasting of election results, engaging in work for a political party or candidate, publication of polling information and opinion surveys. Monetary contributions to a fund may constitute expression, for example, donations to a candidate or political party in the electoral context, though not where the expenditure of funds would be regarded as the expressive conduct of the union as a corporate entity. That's interesting. And there's case law supporting all of this. Political advertising on public transit vehicles. So we had some stuff going on here where in Vancouver the Transportation Authority denied somebody putting advertising on there, and that got overturned. Yeah, that got challenged in the court. Charter rights were protected, as I recall. Freedom of expression also protects the right not to express oneself, a point that is often missed. But this is such an important point. If it truly is freedom, then you have the freedom to do or not to do it, to express or not to express yourself. Freedom of expression necessarily entails the right to say nothing or the right not to say certain things. Silence is, in itself, a form of expression which, in some circumstances, can express something more clearly than words could do. Thus, forced or compelled expression can constitute a restriction of Section 2B. The Ontario Court of Appeal held that the requirements to recite an oath to the Queen at citizenship ceremonies does not infringe freedom of expression. Caution should be exercised when citing this case, though. The case law related to this, which is McAteer and the Canada Attorney General, 2014 ONCA 578, in case someone wants to look up. The appeal was denied. Caution should be exercised when citing this case, as this case seems to be consistent with the Supreme Court's broad interpretation of Section 2B of the Charter. Hello, BigZebra.com. Thank you for joining. You just came in to wish us a happy Canada Day. Thank you very much. Happy Canada Day to you too. Doesn't matter where anybody is in the world. I say happy Canada Day to everybody. A regulatory requirement to file information reports may amount to a restriction on freedom of expression where failure to comply is backed by sanctions such as fines or imprisonment. The act of complying with the law is not the same as being compelled to express support for the law. There's a distinction there. Because there may be a lawful order to provide your tax records to Revenue Canada. You have to do this. Whereas there are, or you have to tell them you don't have them or something. But you have to be truthful about that. Whereas if the court can't order you to express a feeling of support for those regulations. So, two very different things there, although they can seem very similar to people if they're not, if it's the first time looking into these kinds of things. Similarly, the compelled payment of taxes to government for use in funding legislative initiatives does not necessarily imply an expression of support for those initiatives. So that's also important because we all pay into the tax system, and the taxes are used for a whole bunch of different things. Some people don't support certain things that the taxes pay for, but the taxes still go to these things. For example, some people believe that certain health care they shouldn't have to pay taxes for health care for people who get lung cancer from smoking, or for people who need to get abortions or want to get abortions. And these are, we're living in a society where everybody, including those people who need those services, are paying into it so that we can all help each other to benefit. And so that's very important. So there are some people who don't support public health care in general, but the taxes still go to that. That is part of living in Canadian society, and we go back to Section 1. This is a reasonable thing that we're doing here. Streaming Demon, look at the trees. I just wrote that. Thank you. That's funny. It is not necessary that an expression be received and subjectively understood for it to be protected expression under Section 2. So you could be out in the woods all alone, nobody's out there, maybe there is some disaster there and there's no animals around either. Nobody's hearing you express and yell and scream or sing out loud. You still have the right to do that. You have freedom of expression there. It's irrelevant whether there's an audience for what you're expressing. So, the physical sale of a non-expressive product, such as cigarettes, has been found not to be a form of expression. The yellow coloring of margarine has been found not to be a form of expression. The method and location of this expression remove the protection. The Supreme Court has stated that the method or location of the conveyance of a message will be excluded from 2B protection if this method or location conflicts with the values underlying the provision, namely self-fulfillment, democratic discourse, and truth-finding. In practice, however, this test is usually just applied to an analysis of the location of expression. The method of expression is generally considered to be within Section 2B protection, unless it takes the form of violence or threats of violence. And there are regulations in our criminal code that require that that anybody who criminalize expressions of committing an act of violence, like a threat of violence. Death threats are another example of that. It's probably more easily come to mind. Thank you for noting, look at the trees, that the audio is working great. I'm glad we've got audio working well, at least. Maybe the next video I make will have video working properly again. So, method of expression. Expression that takes the form of violence is not protected by the Charter. The Supreme Court has held that whether or not physical violence is expressive, it will not be protected by Section 2B. Threats of violence also fall outside the scope of Section 2B. So, let's see. In other respects, the form or medium used to convey a message is generally considered part and parcel of the message and included within Section 2B protection. And location, whatnot. I'm just taking a quick look at the other things. Okay, let's see. We're going to go on to the next two subsections of Section 2, and then I'm going to end the stream, but we've got a bit of time here. So Section 2C is freedom of peaceful assembly. So everyone has the following fundamental freedoms. Notice the word everyone is used, and it's not just all citizens. That's because people who are visiting from other countries also can join groups here. Now, Beamsy, welcome. Thank you for joining us. And just before I get into Section 2C here, Beamsy is asking me a question about 2B, freedom of expression. He's asking, would you agree with the idea that you cannot be free with the freedom to offend? Cannot be free without the freedom to offend? In principle, I would say I generally agree with that. To be clear, I don't look at it as the focus point of freedom of expression, but rather it is something that's covered under the umbrella of free expression. Because if what I'm saying is offensive to somebody else, I'm not intending to offend them. There's no problem with that. They are, in my view, and they have just as much right as I do to say something offensive right back to me, or to inform me that they're offended by it. Now, if somebody finds something I'm saying offensive, in most situations I will try to accommodate in some way, and I would apologize depending on what's calling that and whatnot. Okay, so what the Beck is telling me that looks like we have a 15-minute delay going here. Oh boy. May have to wait 14 to 15 minutes for the answer. I thank you, everybody. I do not know why this delay is here. So we're moving on to Section 2C. Thank you for that question, by the way. Everyone has the following fundamental freedoms. Freedom of peaceful assembly. Similar provisions may be found in other laws, such as the Bill of Rights and International Covenant on Civil and Political Rights. Jurisprudence. The purpose is that jurisprudence has not provided extensive commentary on the purpose of Section 2C. However, what little there is would appear to indicate that freedom of peaceful assembly is geared toward protecting the physical gathering together of people. The object or purpose of gathering, however, is not protected under Section 2C. As discussed further below, there is a body of case law indicating that the purpose of freedom of peaceful assembly under Section 2C is largely derivative of freedom of expression under 2B. Freedom of assembly is speech in action. And there's case law supporting this. Probably looks like quite a bit of case law here. While acknowledging assembly can be a particular means or modality of expression, the intrinsic value of peaceful assembly as more than an incidental or second-order freedom has also been recognized. The Supreme Court has referred collectively to the Section 2 freedoms as protecting rights fundamental to Canada's liberal democratic society. Under analysis, freedom of peaceful assembly protected under Section 2C, the Charter has received only limited judicial interpretation. Given its strong expressive component, applicants have been inclined to argue Charter issues potentially related to Section 2C instead under Section 2B, and even if submissions on Section 2C are made, courts tend to resolve the issues under 2B. So that's interesting. Section 2C includes the right to participate in peaceful demonstrations, protests, parades, meetings, picketing, and other assemblies. It protects the right to demonstrate on public streets. The freedom also extends to protecting the right to camp in a public park as part of protest activities, and the ability to wear masks during a peaceful demonstration. Now, this was before we had masks being recommended during the COVID-19 pandemic. I see that Ox has joined us. Thank you, Ox, for being here. Appreciate you tuning in. The freedom also... Okay. However, it does not protect a particular venue for assembly, such as a clubhouse. Section 2C guarantees the right to peaceful assembly. Now, there's emphasis on peaceful. That means that this section does not protect riots and gatherings that seriously disturb the peace. It has been stated that the right to freedom of assembly, along with freedom of expression, does not include the right to physically impede or blockade lawful activities. Some jurisprudence has found that legal measures affecting freedom of assembly through the reasonable regulation of public space and associated public health and safety matters do not infringe Section 2C. Similarly, Section 2C was found not to be infringed by measures restricting residence in public spaces by the homeless. In that case, however, the measures were found to infringe Section 7 of the Charter. Other jurisprudence has treated such measures as infringing Section 2C, but as being justified under Section 1. So I'm just going to quickly move on to the last one, of the last part of Section 2, which is D, the fourth one. Everyone has the following fundamentals, freedoms. Freedom of association. So this doesn't mean association like meeting in public, but association that you are identifying as being part of a particular group. See, the purpose is that freedom of association is intended to recognize the profoundly social nature of human endeavors and to protect the individual from state-enforced isolation in the pursuit of their ends. It protects the collective action of individuals in pursuit of their common goals. It functions to protect individuals against more powerful entities, thus empowering vulnerable groups and helping them work to right imbalances in society. It allows the achievement of individual potential through interpersonal relationships and collective action. This is so important. Hello, Pixie Storms. Thank you so much for tuning in. Really appreciate everybody being here. So the Supreme Court of Canada's approach to freedom of association, this is analysis now, has undergone significant revision, starting with Dunmore and Ontario in 2001, 3 SCR 1016, and Health Services and Support Facilities Subsector Bargaining Association in British Columbia, 2007, 2 SCR 391, Health Services. Caution should therefore be exercised in relying on case law which predates this jurisprudence. This applies particularly to pre-2001 decisions in the labor relations context on the freedom to associate as opposed to the freedom from compelled association, the most of which have been overturned. The so-called Labor Trilogy, as well as Professional Institute of the Public Service of Canada and Northwest Territories and Delisle in Canada. However, it also applies to decisions outside the labor relations context, such as Canadian Egg Marketing Agency and Richardson, 1998, 3 SCR 157, CEMA at paragraphs 105 and 101, where the court had held that only the associational aspect of an activity and not the activity itself are protected under Section 2D. In MPAO, the court describes CEMA as applying a narrow view of freedom of association. And again, it's one of the important things with our charter is that the application not overshoot or undershoot. So what they mean by narrow is probably going to be an important aspect in the reflection on how they're ruling in the case. Freedom of association protects three classes of activities. 1. The constitutive right to join with others and form associations. 2. The derivative right to join with others in pursuit of other constitutional rights. And 3. The purposive right to join with others to meet on more equal terms the power and strength of other groups or entities. Under the constitutive right, the state is prohibited from interfering with individuals meeting or forming associations, but is permitted to interfere with the activities pursued by an association. The derivative right protects associations' activities that specifically relate to other constitutional freedoms but does not protect other activities of the association. The purposive right protects associations' activities, including collective bargaining and striking, like going on strike, an employment strike, job action, that enable individuals who are vulnerable and ineffective to meet on more equal terms the power and strength of those with whom their interests interact or conflict. Freedom of association is not merely a bundle of individual rights, but collective rights, which inhere in associations. Section 2D does not just protect activities which are capable of performance by individuals, as there are certain collective activities, such as singing in harmony, which are inconceivable at the individual level. Section 2D does not protect an association's activities that are aimed at enhancing social imbalances. Associational activity that constitutes violence is also not protected. So, freedom from compelled association is also protected. So I think what I'm going to do is just end the stream, but I'm going to let it go for a little bit before I cut it off. I want to make sure that everything has been heard. I'll just read the rest of the sections, their titles, and then I'll end this. I thank everybody for tuning in here. I'm really, again, I apologize for these video problems. It was working earlier in my tests. I don't know why it's not working now. There must be something going on with the internet that's cutting traffic down. I've got excellent connectivity here. I always do, so I have to find out what's happening. At any rate, Section 1 is reasonable limits. Section 2 is freedom of religion, freedom of expression, freedom of peaceful assembly, and freedom of association. Section 3, democratic rights. These apply primarily to citizens. The rest are all to anybody. Section 4, maximum duration of legislative bodies. That's Canadian government. Section 5, annual setting of legislative bodies, again, government. Section 6, mobility rights. These are not cell phone rights. These are, a lot of people think mobility means mobile devices. It means that you are free to move around in the country without having to show passports to cross provincial and territorial borders and whatnot. Section 7, life, liberty, and security of the person. This one's very important. Section 8, search and seizure. So this one doesn't allow people to, it ensures that people have the right to not be subjected to unreasonable search and seizure. It has to be properly justified. There has to be a warrant for it. That could be a formal warrant, or there could be probable cause or whatnot. This is primarily on the conduct of police. And police in Canada are generally quite good with this. Section 9, arbitrary detention. You cannot be arbitrarily put into detention here in Canada. There has to be proper justification for it. Section 10, there's general, which includes the right to be informed of reasons for detention or arrest, a right to counsel, that's legal counsel, that means a lawyer, and habeas corpus. Section 11, general legal rights apply to those charged with an offense, and so that includes the right to be informed without unreasonable delay of the specific offense charged. So while the police officer is struggling to get the suspected criminal into the back of their car so they can transport them to the police station for processing, that would be a reasonable delay because they're in the act of placing them into custody or into temporary detention in the back of their car. Unreasonable delay would be to leave them there and not tell them why they're there once they're ready to listen and find out why they're there. Trial within a reasonable time. There are some countries in the world where it can take a very long time to get a trial, and some of them very sadly leave innocent people in prison until for many, many months, and perhaps even years in a few cases, before they get to hear their charges in a court of law.